Okay, welcome back everyone for the fourth session of day 2 of the 9th Asia Pacific ADR virtual conference. Our final session will have our speakers discuss innovative suggestions for virtual and remote hearings. The moderator for the session will be Mr. Kap-You Kevin Kim, Senior Partner at Peter & Kim, and our speakers are Mr. Toby Landau, QC, Barrister and Arbitrator of Ethics Court Chambers, Ms. Hyun Lim, Secretary General of KCAB International, Ms. SeungMin Lee, Partner at Peter & Kim in Singapore, Dr. Lars Markert, Partner at Nishimura and Asahi, Ms. Chie Nakahara, Partner at Nishimura and Asahi, Mr. Eugene Tay, Partner at Mayer Brown, and last but not least, Mr. Ingloong, Partner at Latham and Watkins. That is all our speakers, so Mr. Kim, when you're ready, please take the floor.
Okay, hi everyone. Welcome to the last session of ADR conference. We have actually many speakers in this session. Actually, what happened was we had the previous session on the so-called SOAP protocol on video conferencing. That was 2018. That's 2018. We had SeungMin when she was actually with my usual opposing law firm, and we have Eugene Tai and Ingloong. So Ingloong and Eugene and SeungMin actually participated at making the SOAP protocol in 2018. At that time, actually, the COVID-19 was never expected. So we just have the idea how we make a more efficient video conferencing in the international arbitration. Now we have totally different situation because the virtual hearing became normal, and almost every day we have the hearing in a virtual way. So we now think about some more innovative ways, some more practical, specific ideas, how we can develop this virtual hearing. So I invited other speakers. So first of all, I invited actually KCAB International, who is the host of this Gangnam Principle SOAP protocol. And also the last year we talked about Gangnam Principle, which is new mode of the arbitration, which is also have some good idea in the virtual hearing. So I invited Hyun Lim, who is the Secretary General of KCAB International, to join. And I also invited the Toby Landau, which need no introduction. He's actually qualified. I can't count how many qualifications you have. It's called basically London and Singapore. And I also invited the 2 speakers from Japan, happen to be the same law firm actually, but very different background. The Lars Markert is a German lawyer actually working in Japan, and Chie Nakahara is like a real Japanese lawyer actually quite doing international work. So what we are going to do is what demand we have in the market, and then try to find more specific ideas, some innovative ideas. When you have an innovative idea, we can think about some more specific idea actually applied in actual arbitration. So before we go into the detail, maybe I can ask Hyun about what is the Gangnam Principle we talk about and the SOAP protocol we discussed 2 years ago.
Sure. Hi, and thank you for having me as a speaker in this session. As we all heard, I was just asked to provide a brief introduction to the Gangnam Principles of Arbitration and also the SOAP protocol on video conferencing, both which are closely related to KCAB International. So first, the Gangnam Principles of Arbitration. Before we start, and just to be clear for those who are not used to, who are unfamiliar with KCAB, the Gangnam Principles are not some sort of rules or guidelines that we insist upon the parties or tribunals in KCAB cases. On the contrary, KCAB International fully respects the party autonomy and the discretion of the tribunals, and we have and we still are successfully administrating many complex international arbitration cases which follow the more traditional mode of international procedures, which is all fine as long as the parties are happy with the time and the costs associated with it. So with that caveat aside, what are the Gangnam Principles? In a nutshell, they involve three broad ideas, all aimed to enhance the efficiency. So really shortly, first of this principle is that parties shouldn't be hesitant to stage shorter but more frequent hearings. Second, counsel should be ready to present a concise but sufficiently detailed presentation of their case at the earlier stage of the procedures. And third, the tribunal should try to spread their workload evenly throughout the procedure and try to interact with the counsel more frequently. So these three ideas lead to a model that we call the Gangnam Arbitration Model, or the GAM, which was partially inspired by what is actually being observed in the Korean or the KCAB domestic cases. So let me just mention two salient points. So there are many, but I'll just mention two of them. First, under this model, the first substantive oral argument actually happened during the CMC. This may sound really strange, but we're talking about a CMC where the tribunal and counsel hold not only procedural discussions, but also hear a very high-level summary presentation of the substantive arguments as well. And this is possible because the initial submissions, the request and the answer, they're sufficiently detailed, and this tribunal is ready to listen to the arguments of the parties. And more crucially, the prospect of a summary, high-level summary, but still substantive argument really focuses people's minds and gets them all up to date on the case file. The second point about the Gangnam arbitration model is that the parties and the tribunal convene for one or even more intermediate hearings prior to the main hearing, evidentiary hearing. But what is new and unique about these intermediate hearings is that the hearing actually sets a stage for what can be described as a group discussion. So what I mean by that is that not only do counsel, but also party representatives, fact witnesses, and even experts are present at those intermediate hearings, and they can actually be questioned directly by the arbitral tribunal, who by that time has gained a pretty good grasp on what the arguments are and what the evidence which are needed are. So instead of just listening to a tightly controlled and pre-rehearsed presentation in a highly formalized structure, the tribunal is free to ask questions to clarify any of the arguments or legal points by the counsel, because the tribunal has read what the arguments are, and the arguments are already there in the previous written submissions. And the tribunal can investigate the points that they feel are relevant to the outcome of the case. So perhaps the main benefit of this intermediate hearing is that the parties are given the fair opportunity to objectively assess where their case is going, and if necessary, reallocate resources before the main hearing. So these intermediate hearings can be scheduled once or even twice, maybe 3 times during the months leading up to the main hearing. So the immediate reaction to the idea of intermediate hearing is that they're too burdensome, they're too expensive, they're hard to schedule, whatnot. And this leads me to the Seoul Protocol on video conferencing. So 2 years ago, as Kevin just mentioned, at this very conference, and involving the very same presenters we have here today, the KCAB supported the drafting and presentation of what is now known as the Seoul Protocol on video conferencing. The Seoul Protocol is a practical tool which lists the basics of a video conference hearing, which the parties and sometimes tribunals need to decide and plan ahead. Each of these items may be small things, but if you miss out on any one of these items, that could lead to unwanted complications and inefficiencies, which could have been avoided. So the full text of the Seoul Protocol is available in the KCAB website, and we've seen it being brought up in various guidelines and introduced by other institutions as well. And in fact, we've seen it actually being used in virtual hearings held here at the KCAB International. So why is all this introduction relevant to the following discussions? The Gangnam arbitration model is just a model. It's a model that was partially inspired by what's actually happening in its institutions. And this shows that with various different participants with different backgrounds and people who try out these little incremental changes and modifications to procedure, we can collectively find an alternative or more options for different cases with different sizes, different needs. And this is the reason why we have these 5 or 6, 7 very prominent arbitration practitioners to share their honest thoughts and maybe give suggestions on why the Gangnam arbitration model might not work in some cases, and also to give guidance to everybody listening in terms of what we can all do to collectively improve the efficiency of international arbitration. So with that, I'll hand it over to our moderator and the speakers to continue with the discussion. Thank you.
Thank you very much. A really good summary of the Gangnam Principles SOAP protocol. I still remember that I was moderating the session in 2018 from London, 3 a.m. in the morning in London time. I really enjoyed that, such an innovative moderating session. So today I try to put some unique background. This is real background. It's not virtual background. It's a bit unusual. So we just to give some idea that it's innovative things. We try to encourage you. We are very open-minded, new ideas, new things. So maybe you can ask somebody who's not participating in this Gangnam Principle or the SOAP protocol, what is the demand in the market? How would be the reactions? May I invite Toby first, and then your observation?
Yes, thank you very much. It's a great pleasure to be part of this. My background is virtual. I should tell you, these are not real books, just to be clear. There is definitely a demand for change. We've had that demand on the agenda now for many years, and it has been the fuel for unending conferences on what's wrong with international arbitration and how we should fix it. Those conferences have been going for a long time. The only thing that has changed is that the location pre-virus became increasingly exotic, and we would fly further afield to discuss the same points. The points wouldn't change. Now, everything has changed in a way that we could never have predicted. We are in the middle of a forced reset. And it's now that the points that that perhaps led to the Gangnam Principles are now upon us, whether we like them or not. And the question is, how do we deal with that? What is the nature of the rethink that we should now do in what is called the new normal? There is here a risk of a loss of opportunity and a risk of a major mistake, in my view. And that risk is that what we now do is we translate into a virtual world everything that we did in a pre-virus world. So we try and use the new technology and the new opportunities to recreate the same things that we have all been doing for so long, and also we've all been criticizing for so long. And that would be a real loss of opportunity. We actually have a golden opportunity now to get to the fundamental problems of international arbitration and try and come up with some solutions. To do that, I think what one has to do is to focus on what are the key features of this new normal. And to my mind, there are some specific advantages and specific disadvantages of the new system of remote hearings that will really point the way to creating a new system. In terms of advantages, we now have the ability, unimagined before, to convene hearings incredibly easily. We can travel the world from our own rooms without leaving. We can switch on Zoom and we can be anywhere in an instant. That means you can have many more hearings easily arranged than in the pre-virus world. You can also involve more people more easily. You can have the client involved at hearings without difficulties of logistics, difficulties of matching diaries. You can have hearings in a shorter space of time, because people don't have to build in the time taken for traveling. So that is a major advantage. Second major advantage is that we are all being forced into an electronic world in terms of documents. In the old days, a lot of people, especially members of the English bar, I'm not naming names at the moment, but many members of the English bar would travel with boxes of papers. And then they would unload the boxes of papers and they would recreate an English courtroom wherever they are around the world. And that also was expensive and difficult, and for some of us with weak backs, problematic. Now it's all electronic, and whether we like it or not, we've had to learn how to use electronic documents. So we are all arguing cases from electronic bundles, and that also speeds things up. It makes it cheaper, it makes it easier to access information. And actually, and we'll come to this perhaps a bit later, it makes it for the first time incredibly easy for the tribunal to navigate what may be, in many cases, a frighteningly large documentary record. Now, that was something which became an excuse for tribunals not to navigate the record so much, or to wait for the parties to steer the way and show the tribunal what they should look at. In a world of electronic bundles and hyperlinking from submissions, that is now inexcusable. And therefore, tribunals can more readily be actually rolling up their sleeves and engaged in primary documents. But there are disadvantages also, and those disadvantages will also have to dictate what is going to be a new normal in terms of procedure. In particular, we cannot have hearings of the same duration that we used to have. And that is because it becomes incredibly difficult to be looking at a screen for a long period of time, incredibly difficult for an advocate to be arguing through a camera for a long period of time. So that means our notion of what is an arbitration hearing has to change. They can't be long and cumbersome. They've got to be shorter and more agile, and perhaps have more of them instead. Secondly, there are limitations of oral advocacy. It is incredibly difficult to do what I'm doing at the moment, which is I'm looking at the camera because I want you to believe that I'm looking at you. But actually what I want to do is I want to look here, to be honest, or down here. But if I do this, then in terms of advocacy, that's not very helpful for you. And of course, what I don't want to do, which is a disaster for me, is to look here, because now I'm looking at myself, which is an awful experience if you are an advocate. So these are things which you wouldn't actually, you wouldn't have to deal with normally. Equally, I can't tell what your reaction is. So I haven't got this sort of the feeling of the chemistry you would have in a room. I don't know whether you're liking what I'm saying. I don't know if you're disliking it, or if you are, as is probably the case, already irritated. And so in a person-to-person exchange, I would be able to modify my performance. Can't do that now. So that means we've got to try and modify what we expect from advocates and what we expect from the art of advocacy. And that also means perhaps now greater dependence on writing in a way that we never had before. If written submissions actually set up the framework now in a way they didn't previously, that will actually inform us in terms of the model. I'm going to stop speaking very, very shortly, I promise. But the one thing I want to end up with on this is I see this as a major challenge for what is the fundamental model that we have all blindly accepted for so many years. And that model, and here apologies to everybody back in London and all my colleagues, that model is the Anglo-US model, which for some reason we have universally adopted. The Anglo-US model of dispute resolution is based upon what has been called the principle of unpreparedness. Now that's to describe the position of the tribunal. The principle of unpreparedness, it was once identified by F.A. Mann, is that the tribunal is not expected to be prepared. They come to the hearing to be educated by counsel, and they get educated by a series of written submissions and then by oral elucidation during hearings. Of course, again, I'm not naming names, although I'm very tempted. There are members of our arbitration community who have become masters of the principle of unpreparedness. And now in this new normal, that is unforgivable. We can't have that model anymore. We've got to have tribunals who actually are interventionist, who take the lead, who actually actively case manage, who take a dispute by its neck and decide what is needed, and then to use the new technology to craft something which is tailor-made, which is bespoke. So we can't have tribunals now on autopilot. We can't have disputes beginning by a tribunal pressing the print button on their computer and churning out their standard procedural order number 1, whatever the dimensions or nature of the case, because the system doesn't really suit it anymore. It actually never did previously, but now we've got to face up to that. And so really what that means is facing the model by actually perhaps looking more to, may I say, a Korean model or a civil law model, where actually we don't just allow the parties to do what they want. The burden is on the tribunal. It's a heavy burden. Many tribunals don't like it. Counsel sometimes don't like it. But where the tribunal actually is in the driving seat and they dictate what to do, and perhaps they dictate something very different from what people are used to. And the last thing I'll say is, what that will also require is a reconceptualizing of what is due process. Because at the moment, it is due process paranoia, or the all-pervading fear on the part of tribunals about doing something different, which is the major disincentive for creative answers. Tribunals think it's safe to do what everybody's expecting. And nowadays, we will have to say, well, from the future going forward, we'll have to now say, due process may mean something different. It may mean you don't always get the hearing you want to have. It may mean you have to accept what the tribunal is asking you to do, and perhaps you're not allowed to speak for as long as you want to, or you have to write on different issues than you want to, etc. And all of this is both frightening, but extremely exciting. That's all I'll say.
Thank you very much, Lars. So Toby is really important and the insight. Maybe I can invite the civil colleagues, particularly from Japan. Maybe may I ask Chie some comments on that? What is demand in the market?
Comments you want, or some long talk is allowed? Just short comment on Toby's presentation, or what?
Actually, whatever is fine, but actually we have time constraint, maybe short.
Okay, coming from the civil law background, I have to agree with what Toby said regarding the demand for the market, regarding the tribunal taken and getting in the driver's seat and try to guide and not just wait there to be, driven somewhere, and let the person be in the back seat and go wherever they want to go. So I totally do agree with that. And I would like to say that the positions of the parties evolve, during the course of the proceedings. And since it does, what happens is that submissions made later in the proceedings have more weight than earlier submissions. So the sum of the value of the earlier submissions, if not all, get lost. And that's not efficient. And I think so it's the tribunal's proactive role in sorting out the issues and letting the arguments, counter arguments, kind of like match and respond to each other's argument should happen.
All right. Maybe you can, I understand that we now have good consensus that we need something new. It's not necessarily new, but it's something more practical or efficient things. Maybe we can hear from all of you about any specific ideas. I can suggest that my colleagues from Hong Kong and Singapore, because they are practicing in Asia and they're more familiar with the common law background. So and any specific ideas they have, and then we have a Korean lawyer in Singapore. So we can hear from 3 speakers, Singapore and in Hong Kong and Singapore, and then move on the other areas. So may I invite Ingloong first?
Kevin and colleagues, a very good afternoon. I want to start with a disclaimer. I was part of the original group of 4 people in 2018 who spoke on the Seoul Protocol. My disclaimer is that none of us was instrumental in triggering the COVID-19 situation because we never foresaw it coming. If I may then pick up on Toby's point, broadly speaking, I'm in broad agreement with Toby, although he puts it far more eloquently than I can hope to. I see the current international public health crisis as an excellent opportunity for us to revisit the old existential chestnut, which is, has international arbitration strayed from its original objective and become too much like litigation? International arbitration, if we can go back to the basics, was meant to be an efficient and cost-effective form of dispute resolution and offers a credible alternative to litigation. It is meant to be a flexible and quick process whereby two or more disputants take their dispute to a neutral and independent third party to seek a binding resolution within a short time. However, in the course of its adolescence and development, international arbitration has started to mimic, as Toby has averted to or alluded to, mimic common law style litigation by the replication of too many of the procedural steps in litigation. So we have our standard procedural order number 1, which essentially is very much like a timetable in an Anglo-Saxon litigation. And as a result, parties and clients get frustrated by the ever-growing length of time that it takes to reach a final outcome to their dispute. Well, technology is a great leveler and equalizer, an enabler. It gives us, arbitrators, counsel, and parties, an opportunity to mitigate some of these disadvantages that currently exist by rethinking how we can redesign the process of arbitration. Some low-hanging fruits would be, obviously, the reduction of travel or the challenge of scheduling hearings because of the conflicting diaries of 3 arbitrators, where that applies. I had one occasion where an arbitrator wanted to be in Hong Kong and London at the same time and therefore couldn't schedule a hearing until a few days later. And let's take a step back and ask, how can we tap on technology to cut down on wastage, be it time, paper, or cost? I suggest it's about time we consider encouraging arbitrators to create a WhatsApp group or a WeChat group with counsel at the outset of a case to schedule meetings rather than rely on our traditional and old-fashioned emails. Now, some out-of-the-box ideas I might like to suggest for further discussion would include these 6. The first would be the use of mobile apps for routine communication, of course, with appropriate backup to a server, which is secure, because security is everything in this new age. Number 2, encouraging the use of iPads, and this is consistent with what Toby had talked about in terms of electronic bundles. Perhaps, Kevin, you can prevail upon Samsung to sponsor some good iPads for or notebooks for practicing arbitrators. The third would be have an oral hearing for specific disclosure. I think this is something we can discuss later, and Toby or others might allude to that later, rather than sort of the normal routine disposal of discovery applications on paper. The fourth is to create a repository of all documents and communications in the cloud or a secure server, which is accessible by arbitrators and all the parties. This will save time where parties or arbitrators need to refer to something. They can simply go to the cloud and download it. The fifth one is a timely reminder. Perhaps we should all think of creating an app for international arbitrations, which sets reminders to parties about deadlines, document production, etc. And the sixth one is perhaps a default remote hearing mechanism for all procedural hearings, other than the merits hearing. Of course, with liberty to apply for an in-person hearing if the procedural meeting is important enough. So I'll stop there and just leave these for further discussion later. Thank you.
Yeah, thank you. Actually, maybe I can ask Hyun. Hyun can you can propose any ideas about that. But maybe if you can, if you can actually, I'm more interested in that document production because I understand that one of Toby's proposal is that we need no reference schedule anymore. Again, before we hear from Toby again on the point. Many people are talking about document production, while the document production is really effective. So can I invite using your comments and then any specific ideas?
Thank you, Kevin, and thank you, everyone. The comment I will make on document production will be very short. But before that, I'd like to respond very briefly to what Toby has said, in particular, the point that we are living in I think he said frightening and an exciting time. And I'd like to address the two aspects, frightening and exciting. Certainly wearing the hat as an arbitrator, I think it could be an exciting time, given that you have so much more scope to be proactive, inquisitorial, and to make procedure interesting as bespoke. But it's certainly potentially frightening, speaking from the perspective of counsel, when we have to deal with clients who want us to predict with a high degree of certainty how the arbitrators are going to behave. And I think what's certainly interesting, therefore, is the fact that we've had maybe about, as you say, a decade of these discussions about innovation and what's wrong and what's broken, and all these surveys that ask the users and the lawyers and the arbitrators what's wrong. But there is a tendency, I think, in our community to attend these conferences and to say all these interesting and exciting things, but we say them in one context, and then we do something altogether different. So we say one thing and we do something else. So certainly take the point that with the reset, as it were, of the new normal that we live in, hopefully, particularly after today's session, with this litany of different protocols, the Gangnam Principles, the Seoul Protocol, we've got the Kaplan opening, we've got the Reed Retreat, we've got the Delos Principles, you name it, we have a whole bunch of these, that we will move away from the conservatism associated with the dreaded PO1 and have a more bespoke approach. But I do think to assuage the concerns of the frightened counsel, whether from a common or civil law background, more thought should be given to how one puts together this bespoke approach. And to some extent, we don't really have to reinvent the wheel. Although the context in which this other protocol was drawn up, namely the 2018 Prague rules, was totally different from the context in which the Gangnam Principles came up. The reality is we end up in a point which is very similar. And what that tells us is, what that signifies is clearly there is a confluence of opinion in terms of where we should end up. But what I suggest, one of the things I did before today's session is to reread the Prague rules. And I was surprised, as somebody who's spoken on them before, I was myself surprised that a lot of the things that we've been talking about, we probably will be talking about in the rest of the session, has already been documented, and therefore tribunals can feel more excited. They don't have to be afraid because they don't have to start from scratch. When we talk about this idea of crafting a more bespoke or a more suitable procedure, they can go to the Prague rules, they can adapt what they see, and they can use it. On document production, it's pretty simple. I think there is almost universal consensus that whilst some users, lawyers, and parties alike insist that there must be some degree of document production, the reality is what is commonly done today has received universal criticism, both from the lawyers that have to deal with it, the arbitrators that have to deal with it, and often the parties themselves. So I think the answer presented again by a lot of these protocols, for convenience, I will just use the Gangnam Principles today, is that you should discuss at the earliest opportunity whether there should even be a general document production stage, or whether you should only have what we call specific discovery of specific documents, and when this should happen, and how this takes place. And again, not to take away from the from the trendiness of the Gangnam Principles, the Prague rules presents one idea for how this could be expressed. but I'm looking forward to the Gangnam version.
Yeah, thank you, actually. I understand the major difference between the Prague rules and Gangnam Principle is that Prague rule is more like adopting civil law approach, I would say. The Gangnam Principle is not a civil law or the common law. It's something we just find some more practical way to proceed. So maybe we can discuss a bit more in detail later. So may I invite the Korean lawyer in Singapore?
Hello, everyone. Thank you so much. I already really enjoyed the session because 2 years ago, the same session on the same topic that we had at that time, it really triggered us all to think about this video conference when nobody was really actually interested in that. And it led to the launch of the SOL protocol at that time. And today already very interesting ideas already exchanged. So I think this is going to definitely help the launch of version 2.0 of the SOL protocol. Especially we all agree, and echoing what Toby has said, was we all this should use this opportunity to start doing the new stuffs. But I'm not sure if Toby was also envisaging to the degree what Ingloong has suggested, which is to create a group chat amongst the councils and the tribunal, or create an app for remote hearings. This is very, very advanced. So a variety of ideas already exchanged, and I really love the fact already about that. Now, one thing that I could suggest is just focus on the video hearing to be a default. This is something that maybe we could all think about. So video hearing, has been already very common in our lives. And the law generally provides for it, and the technology makes it possible. The only thing that remains is for the parties to embrace its use and dispel the perception of its inadequacy. But now, if we take a step further, there are actually already talks about whether this should be a default and the new norm rather than a temporary measure. And if so, what true justice is on the brink of being sacrificed if we adopt video hearing as a default rule? A party's right to present its case and respond to the case against it has been held to be a fundamental rule of natural justice. In this regard, a party's right to be heard stems from the party's right to be treated with equality and to be given a full opportunity to present its case. A party to participate in the virtual hearing, despite this objection, may argue that it has not been afforded a full opportunity to present its case for a lot of different reasons, from disadvantages of arbitrating across different time zones to lack of stable internet connection. But my question is again, do these complaints, do these grounds really go to the heart of natural justice and the rights to be heard? I have been in a case where I was representing the claimant side, and the other part was other respondents. I was saying that the video hearing will be infringing their fundamental right to be heard in person. They have cleverly sneaked in this language, fundamental right to be heard in person. But the tribunal was so smart enough to see through it. So do we have the fundamental right to include the in-person part here? Historically, the right and the concept to be heard, right to be heard, was born and was finally achieved through shedding a lot of blood in the past. But around that time when we were fighting over it, did we have videos? Did we have video hearings? No. So the question becomes, what fundamental right will be harmed if we make this as a default? If this is the real norm and the principle? That's the question I would like to raise to everyone. Is the right to look into the eyes of the tribunal in person such a fundamental right that we have to achieve? And it will harm the due process itself? There's an interesting Singapore case, and the parameters to the right to be to a full opportunity to present one's case were recently clarified by the Singapore Court of Appeal. The Singapore Court of Appeal found that the right to a full opportunity to present one's case under Article 18 of model law is not an unlimited one. The party right to be heard is impliedly limited by considerations of reasonableness, fairness, especially in cases where the complaint is the failure to grant some sort of procedural accommodation to a party that has adversely impacted that party's due process rights. So although I have to say, In person, I prefer in-person hearing very much. I love the small chit chat I can exchange with other counsels and the tribunals over coffee breaks. And also, I love when we all gang up on the other side, when the other opposing counsel is very mean to the witness, and we all gang up and stare at the person saying that. And that's something that I really miss and I really prefer. But going back to the ultimate fundamental basic, is that really conducting a virtual hearing as a default rule, is that going to harm the fundamental right to be heard? I would say maybe not. And this is a discussion we would be able to share today. Thank you.
Thank you, SeungMin. Maybe now we have the German lawyer who is actually known to be a typical civil law. We thought that we all learned from Germany in the law, civil law, civil procedure law, both Japan and Korea. So I want to hear from Lars, what is your observation and any particular ideas out of box the thought about it?
Yeah, maybe let me present something that if I tell this to a German lawyer, they would say that is nothing new. Why are you telling us this? But in connection with international arbitration, and especially one that is very influenced by common law, it might be something relatively new. So what I suggest is, since we now have the benefit of virtual hearings, why not have what I call a first early hearing, which is a hearing after the first round of submissions. So it kind of is already inherent in, I think, what we heard on the Gangnam Principles. So the idea would be the parties submit their first round of submissions, but before there is a document production, the tribunal meets with the parties and has a discussion on the facts and the law. Slightly different than the Gangnam Principles, it would be without experts and witnesses. So that would not be the purpose. And it would be a bit more streamlined than, I think, the freestyle discussion that is envisaged under the Gangnam Principles. So it's probably more a part of Berlin than a part of Seoul, if I attach it. So it's not Gangnam, but a different part of the city. So what's the upside of that? I think there's two major upsides. One, to come back to Toby Landau, is basically it forces the tribunal to prepare. So there's no German lord that said anything about this, but it would be the principle of preparedness rather than unpreparedness. The second upside is whatever comes out of the discussion, I think the parties will have a better sense of what to do in the second round of submissions, what to focus on, and what to maybe leave out, because they realized it's clearly not interesting to the tribunal. So that's a first suggestion I have. Something I've noticed to stay a bit with the German tradition, I've had this in a couple of German arbitrations. Kind of the cherry on top of that is that at the end of the hearing, the parties and the tribunal agreed that the tribunal will provide preliminary views on what the parties have said. And of course, there was an understanding that no party would challenge the arbitrators for what they're saying. And of course, there was an understanding that this is, of course, fully without prejudice. But that made this first hearing even more effective. Because, of course, once you know what the tribunal is starting to think, you're much better in place to shape your submission. The tribunal really has to prepare, otherwise it cannot give a sensible preliminary view. And the additional upside was I had cases where the parties settled because they walked away and they said, okay, our strongest argument clearly is not convincing to the tribunal. And right after the hearing, the CEOs of the parties met, they shook hands, and the issue was done. So in terms of efficiency, that was really a good thing. So as I said, maybe to some common law lawyers, a bit shocking, but if I tell this to a German lawyer, that he would say, or she would say, that's old news.
Okay, thank you. Maybe I'm going back to Toby again. So we heard that your idea is we need something new and something not that familiar with before. So any more specific ideas you want to suggest other than just active? Okay, when you invite a more active tribunal, what ideas, specific ideas we can propose?
Thank you. I have a large number of specific ideas. Some of them I can't articulate at the moment because they involve naming individuals who should be on a blacklist and not sit as arbitrator. So, and that's, I think, for closer to the time of my retirement. So I'm going to stick to some more generally applicable proposals. Let me come, first of all, I'll come to two of them because we've got limited time. The first one is on the particularly unexciting topic of documents. With all due respect to Alan Redfern, who did a brilliant thing in inventing the Redfern schedule, the Redfern schedule now has become something that he would never have wanted. It is actually now quite a cumbersome part of the process. It is utilized in many, many cases, and it is quite a costly element of procedure as well. It takes a lot of time for the parties to put it together. The problem with it comes, I'm afraid, from the tribunal side, because many arbitrators now use the Redfern schedule as a shortcut instead of actually getting into the issues and actually understanding each of the document requests. They use the schedule as a way of not reading the record, so that they're simply reading a summary position for and against the production of each document. Now, that's often because Redfern schedules are so long. If you were to go through and study each request one by one, you would probably lose the will to live. So tribunals don't have that patience because it's dull and it's an awful, painful exercise. So it's really ticking boxes. Now, the problem also is that ticking box exercise gets infected by tribunals already their assumptions as to whether there are too many documents generally asked for in arbitration. Many tribunal members will tell you that. Too many documents being produced, too much costs not needed. Now, every case is different. There are many cases where there are too many documents, but not every case. There are cases where you need the documents. There are cases, for example, on corruption and fraud, where you need to take a different view. You can't just sit back on a burden of proof approach, because a party who's trying to prove something in that kind of case is likely not to have available documents and will need them. So each case has got to be looked at individually. And I think the Redfern schedule has become very, very unhelpful in stopping tribunals from actually rolling up their sleeves again and getting into the detail. Now, here's where things have changed, because if you can now have hyperlinking and electronic bundles, you can actually allow the tribunal an easy way of accessing individual documents and understanding issues in advance. And more particularly, with the ability of convening readily, easily, virtual hearings, you don't need a schedule which the tribunal has to then be tucked away with in their rooms for however many days or weeks trying to understand. You can actually have many short remote hearings where individual points are explained and where, for example, parties can take the opportunity to take a few document requests and show the tribunal with hyperlinking on an electronic bundle exactly why a point matters, something which we couldn't have done before. So I think that actually is a way into completely revolutionizing the way we deal with document requests. And it has the advantage, of course, of educating the tribunal early on what the real issues are in an easier fashion. So that's what I would say on document disclosure. Kevin, I don't know if you want me to take more time, but I could then go into what is I think a slightly more interesting proposal, which is on post-hearing briefs. I'll carry on until somebody cuts me off. Actually, it's my general rule of life. So on post-hearing briefs, what I think has happened is certainly in pre-virus world, we have got to a situation where people expect that they will be allowed to serve a post-hearing brief as a fundamental human right. It is just assumed in most cases. The idea is that we will have a post-hearing brief, And that means that people will conduct themselves with a view to putting everything in full detail finally at the end in that final submission. Now, I think there has been a curse of the post-hearing brief. Post-hearing briefs can be very helpful for a tribunal, obviously, in collating all the information. In particular, where they're vital is when you need to bring together the evidence that has been adduced during the course of a hearing. If you've had a week or maybe 2 weeks of cross-examination, you want somebody to bring together the transcript and let you know what they feel has been learnt during the course of that testimony and how it helps or undermines a case. But here's why it's a curse. Because in the old days, what would happen is the tribunal would simply switch off as the hearing progresses, thinking, I don't need to engage completely now because it will all come later in a comprehensive post-hearing brief. If you are a busy tribunal member and you have many heavy cases, then any opportunity to switch off will be embraced because you've got other things to do. So why spend all your time now going through all the memorials in detail if you're going to get a full statement later? Indeed, what it would also do is stop parties from making oral summations or summaries at the end of a hearing, because they say, well, there's no point doing a closing argument because it's all going to be set out in post-hearing briefs. And very often the situation vividly I have in mind is that you get towards the end of a hearing in the old days when we used to be in the same room, and the tribunal would actually not be listening to counsel or witnesses at all anymore. They will be looking at the clock and working out how long it's going to take them to get to the airport to get their flight either home or to their next hearing. And so there's this kind of wind down moment because it doesn't really matter because there's not going to be a grand finale. That will come later. Now, here's the other problem. Post-hearing briefs often come weeks or months later. And in the meantime, memories fade. That means tribunals are not still with everything at their fingertips. They may have gone off and heard many other cases in the meantime. So when the post-hearing briefs come, you've lost a lot of very valuable time, where actually when things are fresh, the tribunal could be deliberating and could be coming to some conclusions. It's also problematic for parties because parties will use post-hearing briefs as an opportunity to rehash everything. So tribunals often get burdened by massive tomes, huge memorials, which restate everything again. There are ways around that, but actually I think now we need a more fundamental rethink on the post-hearing brief, because one of the most critical moments in a case is when it finishes. That's when everything should have crystallized. Everything comes together. It's fresh in everybody's mind. It's the time where the tribunal should actually be deliberating straight away. It's what many national court judges would do. And it's a time also where their thinking may well become more orderly. I have experienced often that you get to the end of a hearing and you're not quite sure how everything fits together. And then if it's all fresh in your mind, you go away and you start thinking and you start doing some writing, and then more points arise. And then it all comes together. But that's when often questions arise. And that's when actually, ideally, as an arbitrator, you want to say to the parties, yeah, but what about this point? And you haven't asked that question previously. And you don't want to if it's going to be a post-hearing brief because it becomes procedurally disorderly. And then you've got to wait for time for people to serve more written submissions. Maybe there's another few weeks go by. Now we've got the advantage of instant communication. So actually the ideal would be to have a conversation which can be regulated, which can have due process, it can be fair, but it will be people switching on for a quick remote hearing where parties can come and answer a question. And maybe there'll be a follow-up question the next day, 2 days later. So it's a process then which actually could be very efficient in reducing the scope for misunderstanding, in making sure that any point that a party really wants to put is put, any issues of difficulty are resolved. And actually what I think that would do is not only shorten the time to get to an award, where often you may have delay where the tribunal is worried and troubled by something and trying to work it out, but also it will foreshadow challenges. If you had that process, how can somebody later reasonably say the tribunal never took into account this point? because you'd have every opportunity of raising that point. It would reduce the possibility or the scope for parties to say this bit of the reasoning is unclear, or the tribunal made a mistake, or they just misunderstood this point, they got it wrong, or I was denied an opportunity of saying something. So actually, overall, I think the process would become better and more robust, and the scope for challenges would reduce. That's my proposal.
Thank you. I think one of the benefit we have with this virtual hearing is actually we have the tape recording, which is not that available actually in person hearing. We have transcript, but actually the video footage is totally different thing. We have the video of what witness said, and what you can just replay the relevant portion, that you have a clear idea what witness said, what the expert said, and what the counsel said about the case. So I was thinking about just like why just we just rely on the written submission only. We just make some arguments, by video, and then or just like have whenever we have discussion, we always videotaping what you are discussing. And then we can just tribunal and parties can always replay a little portion and what was discussed. Maybe I can invite Chie. Again, we Japan, Korea, we are neighbors. The law is very similar, practice is very similar. What do you think about these new ideas, or you have any particular new specific ideas you want to propose?
Oh, that before I go to that, I would like to comment a bit on, post-hearing brief that Toby mentioned. I have to confess that as an arbitrator, I like to have the post-hearing brief. You are always expecting somebody else summarize something for you. It's there. You might be able to copy and paste, maybe. We're always fantasizing about that. And I always also have to tell you that when I was a legal apprentice, that I have witnessed the Japanese judges on the stand. One of the judges were taking a nap during the cross-examination, switching off. Example. Then let me share one example that came to my mind. It often happens when that the tribunal issue a list of questions shortly after a hearing, indicating the issues in that list that they would like to wish to see further explanation or arrangement from the parties in the post-hearing brief. I think it's kind of like an often seen practice. One experience that I had was that during the 10-day hearing, at the end of the 9th day, we were given a list of the issues that the tribunal would like to hear further explanations on the next day, the last day of the hearing. We were to make the oral presentation for such issues and for clarifications on the last day. Well, did I like it? Well, working another all night is not something that you love, but you would be surprised to find out how much you can do overnight at the same time. And it was obvious that the tribunal understood the point more with the interaction and discussions with the counsel on the last day, which would not have happened with the submissions of the post-hearing brief in writing, where if those questions were presented to me for drafting the post-hearing brief, what we would have done would have been that we would just present whatever we assumed what the tribunal would be interested in or keen to hear. But actually being asked several questions from the tribunals on the last day, and we realized, oh, that was the point that you were interested. We had no idea from the list of the issues. And also looking at the opposing party making the case on the same issue. And it was very good a discussion actually, and in this way, it worked better in some cases. And also it can preserve the interaction between the parties and the tribunal and can serve the lengthy post-hearing briefs. So going back to what Toby said, but we have to say that doing that physically was a bit of a challenge. As I said, we only had several hours to prepare. So if we can have such short interactive session after the hearing remotely, it would be really helpful, is what I thought.
Yeah, actually, when you have a more interactive discussion, naturally the tribunal will be familiar with that. And actually,
Yes.
we all agree that we have some way to make the tribunal more engaged or
Yes,
active
yes.
from the beginning. But actually, so we are wondering what would be the practical way to make the tribunal be involved from the
Yeah.
right?
You
Maybe
know,
you can pay more compensation to the tribunal, more active involvement from the beginning.
or check whether or not they're taking a nap, you know, every day or every hour. Well, the default proceedings, the main hearing is set at the very end of the proceedings. Further, many arbitrators adopt a very passive approach in terms of providing feedback. Up until the hearing, you know, they are very dormant or uneducated or unprepared, while the counsel are working their head off massively, drafting hundreds of pages of submissions that might lose importance at a later stage. And it is far from efficient. So, I mean, I was thinking, why can't we make the interaction between the parties and tribunal happen at an earlier stage? And I think, so that's the way the Gangnam Principle came about. So where the neighbors, we feel the same. We have the shorter hearings at certain intervals in Japan too. So we thought it would be ideal to hold the preparatory or initial hearing or initial session where counsel will make oral presentation and tribunal shall ask questions, give the parties their feedback. It's kind of like the mixture of Korean Gangnam Principle, German way, and the Japanese way. Actually, 1996 Civil Procedure Code reform introduced to the Japanese court litigations that the arrangement of the issues, preparatory proceedings, I think it's similar to that. So such active engagement of the tribunal lets the parties to filter out the frivolous issues and set the focus on the issues that are essential to solve the dispute. So it saves the counsel to prepare voluminous submissions that every issue that they can think of are crammed, which we have seen in a lot of submissions. So in pre-COVID-19 time, almost all merits hearings were held physically with the burden of traveling cost and time, but the game has changed as we have been discussing. With COVID-19, proactive tribunal actively shaping the case with the additional hearing at the very early stages. It doesn't have to be a long hearing with no additional cost or traveling time is some side effect that we can enjoy with the technology of virtual hearing. For example, with a virtual format, the tribunal can actively shape the case utilizing, for example, the document sharing screen, filling in the chart format of issue list with parties' input on the spot. So at the end of that shorter hearing, the list is there. Also, the parties can agree on undisputed facts and make that in writing at the end of such hearing. So with the new norm of virtual hearing and utilizing the technology, I think the tribunals taking the active role in shaping the case shall be more explored.
All right, excellent, thank you. Actually, no, we have one question from the floor. Like we can this is like an innovative way to proceed the webinar, so we don't have to wait until the end. I think this is a very practical question. What is the best platform or just the program we can use for document sharing and other things? My experience, we normally have three connections: a lifetime, live note, real-time transcriber. So for one, so that is easy thing. But as to the transmitting the video, I understand in many cases we are using Zoom because Zoom has a function that simultaneous translation. So it's when you have a translator, that is quite useful. But document sharing is different thing. I recently have the tribunal have a specific order to stick to that particular program. Just I want to mention the name of the company and the name of tribunal, but I think that is based upon his personal experience, and then I understand that program is quite good. So could you share the this is a really practical tip. What is your best experience at virtual hearing? Anybody can speak up.
Well, maybe I'll give some options that we tried. So what we've done successfully is share the screen, but at the same time have an electronic bundle for the arbitrators in front of them, because often when you share the screen, actually things are too small to read them. And so the tribunal had on their desktops basically an electronic bundle hyperlinked with the exhibits then. Of course, I think there are kind of very professional options. So the more money you pay, I think the more you get. To give you kind of something on the other end, what we also did, and which wasn't so bad, is we had in a smaller case, we had all the exhibits merged, and then we just bookmarked on the site in this one PDF all the exhibits, and it was very easy to jump around in this one PDF. That works for small cases when you don't want to spend so much money.
Okay.
I would just echo that. I think that there are many options now. I have done a large number of cases now just using a simple electronic bundle, meaning that it's just everything converted into PDF, whether it's in one volume or separate volumes, and all properly bookmarked. As long as it's all bookmarked in the same way and everybody's got the same pagination, that is incredibly easy, actually. Even for very big cases. I've done it with cases with thousands and thousands of documents, which have all just been put onto PDF, and it's so much quicker in the end than the old-fashioned paper format. But there are many more expensive options around and more sophisticated options around, including not naming the companies, but maybe there's certain companies who are now specialized. I'm not naming because they're not giving me any money for this, but the kind of it's an all-in service now where you will have somebody, even a technological person, who will be online helping you as you direct them to put up a document, split it out in a particular way, and that can be useful during cross-examination. But otherwise, I think actually one can get through this pretty quickly without that expenditure.
Okay.
Yeah, I second what Toby just said, and apologies to the people I have to go to sometimes for sponsorships for events such as these. Having been part of their user feedback groups as well, I think one of the points I've made to them is simpler is better. I mean, there is a tendency that when they specialize in these platforms, that they make it so complicated that, as Toby says, you have to have a full-time person sitting there manning it, when a PowerPoint is fine, or a PDF, a giant PDF bundle bookmarked and hyperlinked is sufficient. So in terms of, to the audience members' question, just getting the PDFs across and agreeing how you're going to bookmark them or hyperlink them, and that's good enough. You can use whatever viewer for the PDF viewer that you prefer. There are some services out there where in extremely large document-heavy cases like construction cases, they say that from day one you can set up your data rooms both sides, and you can agree the service. Although I think that in theory that's a great idea. I haven't yet seen a case where the lawyers on both sides of the parties have agreed to share that cost from day one. But in theory, if you did that from day one, the tribunal could also be a later module that's added on to the system. Usually the concern is one of security, cybersecurity mistakes made in terms of where documents go and who gets to view what.
All right. I think this should be the covered one of the SOAP protocol version 2. Another question I want to propose is when you think about more specific ideas. We are talking a lot about active engagement by the arbitrators at the early stage, and we are always thinking about how we can make tribunal members more actively involved from the beginning. I think the same applies to the counsel. Some counsel are extremely busy, and particularly senior counsel and the lead counsel, they don't understand the case. They're not prepared actually argue the case before the tribunal, particularly the early stage of the arbitration. So we have to find a way, just like the counsels are very active from the beginning, understand the case, but at the same time, the counsel need time to understand the case, digest the case, and think about the arguments in this way, the other way. without such a time and experience, you will not have the clear idea what will be your argument will be. So one of the problem with that is once you express your views, and then you have problem with that because you're less expressing your view, or sometimes it could be seen as waiver or the admission or some whether or not it's admission or not, you have bad anyway. If you change your story. So how we overcome this problem? There's another. I think that is basically my problem. I'm sometimes sitting as arbitrator or sometimes as counsel. So could I invite you, any of you, just deal with that issue?
If I may add, just going back to the Gangnam arbitration model, I mentioned that during the intermediate hearings, we can envision or plan in the idea of having a group debate of sorts, which might sound very shocking to many people who are not used to it. But it's the premise, I think, that was used in the domestic arbitration settings, and in fact, the Korean national litigation as well, is that you don't have a recording word by word that is left so that the opposing party can just take out sound bites that are just fit for their own purpose and twist it around and use it against you. In fact, as counsel in international arbitration, but being a Korean lawyer in training, one of the things that I found difficult to get over when I first started is having the opponent, usually counsels trained in certain jurisdictions where adversarial system is the norm, to take a few words here and there and just create something new, and and you're basically caught with it. And it's of course, if you have experienced tribunal, they're not amused with it, and they kind of do something to stop it. But if you're a young counsel and you're trying to conform to your clients, it's a bit of a distraction. So I thought, and this is maybe I should have mentioned politics here, but I remember reading a reporting by one of the Korean press about the presidential debate back in the United States a few weeks ago, that the winner of the debate was actually the mute button, because the prospect of being muted kind of suppresses people. But the idea of not having everything fully on record might be something that tribunals or parties may consider and building in. It doesn't have to be like a settlement for purpose type of discussion, but there might be stages where both parties, while they're all present and listening to everybody, and with everybody on site and with a chance to restrain or checks and balances with each other, might say things, or the lay witness might say things that are just simply there to assist a tribunal to understand the case, as opposed to leaving bits and pieces for the other proponent to take and make whatever story they want out of it. So the idea, I think the proper approach, I guess, is for parties to understand, like I think Chie mentioned, that cases can evolve, and you might have a structured idea of what it is, but if you want to weave in all these different bits and pieces and nitty-gritty granular details of the case, you might need some investigation into the facts, and having everything all there real time and set in stone as part of the evidence, I think that puts a lot of burden on the counsel and even on the tribunal to ask things and say things. And in the end, everybody they're just basically playing charades and spending time and not getting to the point right away. So the idea of the factor of maybe having a certain segment of the proceeding, not on a written verbatim record, might be something that you might consider. But of course, it takes a very experienced arbitrator and experienced counsel, and also a party that are not too sensitive about these procedures to weave in and design a proper procedure. So that was the idea that just came in my mind.
We have very limited. Yeah, while we are discussing, we have quite now limited time. Actually, that's exactly what when I proposed the Gangnam Principle, that kind of chaos or freestyle discussion. Well, one thing I proposed was the no transcript service, so there's no record, so that parties can they quote that what parties or the experts said aside. So maybe I can ask some, each of you make some short comments, because we have we have limited time. I think we have about 5 minutes to go. So you might comments on the other ideas, or just add some other ideas. Actually, what we are doing here is actually we're going to make a Gangnam Principle. At that time, the Psy was popular. Now we have the BTS is more popular in Gangnam. So I'll propose that Gangnam Style, the BTS version, and Seoul Protocol version 2.0. So if you guys have any particular comments and what the principle should be, I'd appreciate. Who want to go first?
Very quickly, just a few brief comments from me. I think the broad consensus that emerges from this discussion is that the tribunal ought to play more of the role of a project leader or project manager in the arbitration, rather than someone who takes a back seat and let counsel do the driving. So I think active case management is something that everybody has always been talking about, but perhaps not always practiced in every case. So I think tribunal members do need to take a far more active approach. And I think technology is something that we as arbitrators, for those of us who sit as arbitrators, should fully take advantage of. And I think, Kevin, you also wanted me to say something about Seoul Protocol 2.0. So just a couple of comments. And on this, I think we are now, the committee is now sitting together and brainstorming as to some of the new things that we want to put in Seoul Protocol version 2.0. And I think one of the things that we have thrown up is perhaps the accreditation of certain hearing centers. Given the difficulty of traveling from one jurisdiction to the other, perhaps there could be some sort of system for accrediting national hearing centers or national venues with the appropriate, armed with the appropriate technology to provide a venue for witnesses to testify from. And I think that's something that has yet to be worked out, but we're thinking along those lines.
Thank you. Seems like Chie wants to speak.
Thanks. No. We have been talking about, what would be the new norm or new conventional way to do the arbitration in this post-COVID-19 time. And I say, yes, new wind is blowing. We can put the new sake into the old bag. But at the same time, we have to go back to the basic, the principle. And as Toby mentioned, that the arbitrators are like due process paranoia. I mean, we are so brainwashed that in arbitration, the arbitrators must allow the parties to present the evidence they feel is relevant, whether or not it will play a role in ultimate determination. But I mean, IBA, guidance says that tribunal is encouraged to identify to the parties the issues that it may regard as relevant and material to the outcome of the case, and so on. So we need to go back to the basic and the principle. Arbitrators shall conduct the proceedings so as to avoid unnecessary delay and expense. So it's speedier and less costly arbitration. That they are the cornerstones of the arbitration. That's something that we have to have in mind, is my comment.
Thank you. SeungMin?
Just 1 minute. So I just want to conclude that the best days for lawyers and practitioners would have been maybe the time when there was no mobile phones, no emails. And I think the practitioners at that time would have enjoyed their lives a lot more than right now. Here, right now, recently, after the COVID and the Zoom and everything, I believe the technology is there. There are various options. There are a lot of brilliant ideas and suggestions. The real challenge is actually going to be ourselves, I believe. So are we actually willing to come out of our comfort zone and take the further step to actually be more transparent, more engaging, and actually more tiring? I think that is the big challenge actually for the practitioners. And I think that's something that we need to think about. Okay, thank you very much.
Thank you. Eugene, you want to say something?
Oh yeah, I'll just agree with SeungMin, which is we've got no excuse now not to be innovative, whether on from the bench as counsel or from as arbitrators. But I think my answer to the due process point, and sorry if I can't get away from, as civil law inspired as I am from the common law mindset of saying that the way that we can resolve the tension between who owns the arbitration, is it the parties or is it the arbitrator, is essentially to achieve a conversation. So there has to be a dialogue. And it sounds to me like that dialogue takes place over one or possibly several early case management meetings, where you should be going through all the issues that we discussed today. How proactive an arbitral tribunal do you want? What does that proactivity mean? It means different things to different people, as you can see. How do you frame that in a way that's acceptable? And what happens if the parties and their lawyers simply don't agree? What's the default position? Are you going to be able to rely on some general provision in the applicable arbitral rules, as Chie mentioned, to force a process down the throats of the parties and their lawyers, which they may not be familiar with and which they may find frightening in as much as the tribunal finds exciting? I think that's where the tension is going to lie. And for me, the tools for the arbitrators and the lawyers to achieve this exciting new world are already there. It's just a case of getting familiar with them and starting to use them in practice.
Thank you. Lars?
Well, to stay on the topic of tension, considering how young BTS are, think about the young and motivated arbitration practitioners. They're usually tech savvy. They're really prepared to be proactive. And okay, you might ask yourself, what's the tension? Well, maybe if you really want to guide the parties and conduct this, maybe as an arbitrator, you need to be experienced. So that's going to be the interesting tension, I think, that's going to come up.
Thank you. Toby?
I wholeheartedly agree with everybody. Everybody, I think, on this panel has been traveling in the same direction towards very much a very, very similar conception of what the process should be. But the one thing that's missing at the moment, which to my mind is essential, is a holistic answer that brings in all stakeholders, and that must include national court judges, because the biggest driver for due process paranoia is the threat that an award will be challenged or will not be enforceable at the end of the day. That's a big, as I said before, it's a big disincentive for innovation. If you do something different in the way that we've said you should be doing, might you have in your mind the concern that a judge may not understand it, may not be used to it, may be open to an argument that it was a denial of due process because it's very, very different. It doesn't look anything like many national court procedures, particularly in the common law world, and it doesn't look anything like traditional international arbitration. The best vaccine for due process paranoia is to have judicial pronouncements saying this is not a problem. And we are already seeing it. People are already pointing to the few national court judgments that we have where an allegation that it was a denial of due process to force somebody to have a remote hearing, and that's been dismissed already in at least 2 courts. And the more we actually bring everybody into this procedure, I think the better chances of success.
Thank you very much. We have a really good discussion today, and I think we share the same views, and we have some specific ideas. We developed this idea further, and with the technology, then we can have more the clear idea what we are going to propose to the new normal. The virtual hearing is obviously different from the live or in-person hearing. You're now looking at me. I'm just looking at the screen, not the camera. This is camera. That's what the Toby pointed out. And then you were wondering what is the behind me. You just open the door. It's totally different color. So what we are going to do now is, why don't you open the door as early as possible? What is inside? How is it look like? At the same time, when you are in this room, you immediately recognize what this is about, But if you see by video, you have limited idea what it is about. So we have to overcome both things. So we just take good things from the virtual hearing and in-person hearing. With the combination, we might have a better solution, international arbitration. That's make, as you said, is we're going back to the basic. We provide more efficient and speedy and cheaper solution in dispute resolution in international arbitration. So thank you very much for everyone for joining this this wonderful session, I would say. I really enjoyed that. Thank you very much for KCAB International to organize this, and the other organizers, interpreters, everybody. Thank you very much. Bye.
Thank you. Bye-bye.
Bye-bye.
Thank you for such an interesting discussion. That was our last session, and we now close the 9th Asia Pacific ADR Virtual Conference. We hope our conference has been a renewed opportunity to everyone to learn and connect within the ADR community. We could not have held such a meaningful event without the participation and support of all our speakers and attendees. So thank you to everyone who has taken their virtual seat with us today. KCAB International wishes all of you the best for the end of the year. Thank you, and please stay safe and strong during these times. Goodbye.